Alex here with a high conflict child custody video on exit orders. My understanding is that an exit order is something that is entered in a CPS action when the case is closed. I got to mention a few things right away. What I mean by CPS action or CPS case is, because they're not actually called that, for example, in Nevada, a child abuse and neglect proceedings. In Indiana, C.H.I.N.S proceedings, which stands for Child in Need of Services proceedings. Other states may have different names for the type of proceeding that's instituted by CPS, also sometimes called DFS. CPS stands for Child Protective Services. DFS stands for Department of Family Services. Different states have different names. All these definitions, if you need to rewatch this section of the video, feel free to pause and rewatch it. The point I'm trying to make is that apparently in some states, the CPS action or the CPS court, I'm going to keep using that term just as a general term, it's not actually called that, remember what I mentioned earlier, can enter an exit order when the case closes that sets up some kind of custodial rights as well as visitation rights to the parents involved in the CPS action if they are not together. In other words, it appears to me that some states will allow the CPS action or the CPS court to actually act as a custody court. This does not change my opinion at all in the video abuse and neglect proceedings. If you haven't seen that video, please watch that video, because all of the same principles that I mentioned in that video still apply, even with me having figured out or found out that there is something that allows these CPS courts to act as a custody court when they close their actions. I strongly suspect that this is a mechanism used in states that use the C.H.I.N.S model, which is the Child in Need of Services model. You can watch the video Child Abuse and Neglect Proceedings to get all the details as to what I'm talking about, because I'm not going to go back and reiterate them in this video, but the gist of it is that in those specific types of states, you can't have a CPS action running at the same time as a custody or divorce action. And in those specific states, one of the defenses to the action is potentially that as the other parent, you can object to the child being in need of services, and you can basically refuse the CPS action from having any jurisdiction by claiming that you, as the other parent, are willing to take care of the child, and therefore that child is not in need of services. The reasons I suspect this are based on logic and my fuzzy understanding of how exit orders work. I'm not going to do the research on this. I did not deal with this in my own case. There are many videos that I do where I don't have all of the answers because I didn't go through it myself, but at the same time I think it's crucial for me to let people know when something important exists out there so that my viewers can at least go and look into it carefully. That being said, my suspicion is that this is a mechanism used in C.H.I.N.S style proceedings, which basically allows the C.H.I.N.S court or the C.H.I.N.S case to close when the court feels that the child is no longer in need of services, yet at the same time enter an order that basically sets forth the parents' custodial rights and privileges and all of that going forward. And from what I've looked at, the orders, the exit orders, are entered in situations where the two parents are not together. It makes sense because I don't imagine the court would need to enter any kind of custody order if it returned a child to a couple that was still together. Parents who are still together don't need a custody order. They're still together. They still live together and they're still acting as a cohesive unit. So if anyone here has any experience at all with exit orders, please enter something in the comments below to help some of the other viewers, because I'm confident that Nevada does not use these because of the way child abuse and neglect proceedings work here. They run concurrent with divorce and child custody actions, and my understanding is that those courts do not actually look into custodial issues and do not enter custodial orders. There was one other thing I was going to mention regarding, oh yes, from what I've looked at, the exit order can be modified following ordinary child custody principles in whatever state you're in. My understanding is that a parent can take that exit order and either file it or register it with the regular old family court, whatever it happens to be in your state, and then an ordinary judge who presides over child custody matters will take that order and apply all of the usual legal principles that apply to child custody proceedings, and including issue preclusion, which is one species of res judicata, which prevents a parent from relitigating any of the issues that were already addressed that basically made up that order. So you couldn't just file it with a custody court and just try to get a whole new decision just based on just a whim. The decision from that, the decision in the exit order would be binding, and to modify it, all the ordinary principles that apply. I've done so many videos on this, I'm not going to go and reiterate myself now on how change of circumstances works and how issue preclusion works. If you have any questions on any of those other videos, please feel free to search for them and just go ahead and watch them. But that being said, I'm going to end this video now, and I will see you guys next time.